Hello, everyone, and welcome to Uncivil Law, our working name for this channel. I hope you're having a great day. So, what we're going to do is we're going to review the jury instructions and we're going to listen to the closing arguments in the Amber Guyger trial. So, we did the opening statements, as you will recall. We concluded that the prosecutor did a very good job and the defense not so much. So now, of course, the trial is over. The jury is deliberating. They got the case this afternoon, and they deliberated for a couple hours, and they will be back tomorrow morning to continue. So all that's left is for the jury to decide if they can. And so we're going to listen to the instructions from the judge first because it states the law. And then we will listen to the statements from the. I'm just turning on my do not disturb so my phone won't ring. That's what I'm doing, in case you wanted to know. We will listen to the closing statements. And at this point in the trial, all the evidence has been submitted. So at this point, they might refer to specific things. They might refer to what specific witnesses said. They might even play a piece of tape, 911 audio. They might, because all this has been admitted. So at this point, you can bring all that stuff in because it's part of the record at this point. And it's meant to conclude the story. And so we'll listen to it and try to decide. So we're going to start with a statement of the law. And then with knowledge of the law, we can listen to the closing statements and perhaps make some decisions ourselves as to what we think a proper conclusion might be in this trial. So let's listen to the judge explain the law. This is about 21 minutes. And I might stop to explain some things more, but this should be relatively easy to understand because it is written very deliberately to explain it to an audience with no training and no experience. So it should be written in a way that it should be easy for us to understand. But I may pause it as we go along. So let's see what we got.
That being said, ladies and gentlemen, you've heard all of the evidence that you will hear in this case. At this time, it is my responsibility to read to you the jury instructions. You don't have to memorize what I'm telling you. You'll be able to take these back into your juror room to use during your deliberations. And following my recitation of these instructions, the parties will have closing arguments for you. Jury instructions. Members of the jury, the defendant, Amber Guyger, stands charged by indictment with the offense of murder alleged to have been committed on or about September 6, 2018 in Dallas County, Texas. To this charge, the defendant has entered a plea of not guilty. A person commits the offense of murder if the person, 1, intentionally or knowingly causes the death of an individual, or 2, intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual.
Joe Tyson asked the question, how are jury instructions negotiated and determined in trials? So there are model jury instructions that are approved by the court system. So, because obviously this is not their first rodeo. They've had murder trials before. So there are sets of jury instructions that are model jury instructions. And given the available defenses, you know exactly which instructions to go to. So they might give an instruction on self-defense. They might give an instruction on diminished capacity. They might give instructions on things not to consider, defenses not to consider if they want to specifically exclude things. And then from the model instructions, the judge writes the model instructions up initially, gives them to both sides, and both sides can comment, and they can ask for their own instruction, and they can ask for special instructions to be written if they need. So there's an opportunity for them to contribute. But for the most part, they stick to the model rules, the model instructions, because, this murder is not the first murder that's ever occurred. We have a pretty good idea what to say. So, there's no particular need for special instructions, most likely. So up the volume on the video. Say people are turning up the volume, get their ears blown out when I pause and talk. Yeah, I'm trying to make the audio consistent, but let me turn down my volume a little bit on my mic. Turn it down a little bit. All right, that should be a little better. And I'll turn up the volume on the desktop so it's a little bit easier to hear. Let's continue, but thank you for the note. Hey, Leonard, how you doing? Good to have you. And how are you not a moderator on my channel? I'm making you a mod. You are now a mod. All right, let's continue.
A person acts intentionally or with intent with respect to a result of her conduct when it is her conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause the result. Individual means a human being who is alive, including an unborn child at every stage of gestation from fertilization until birth. Person means an individual, corporation, or association. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or B, anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Now, considering all the law contained in the court's charge, if you unanimously find and believe from the evidence beyond a reasonable doubt that on or about September 6, 2018, in Dallas County, Texas, the defendant, Amber Guyger, did intentionally or knowingly cause the death of both of John, an individual hereinafter called deceased, by shooting the deceased with a firearm, a deadly weapon, or if you unanimously find and believe from the evidence beyond a reasonable doubt that on or about September 6, 2018, in Dallas County, Texas, the defendant, Amber Guyger, did intend to cause serious bodily injury to both of John, an individual hereinafter called deceased, and did commit an act clearly dangerous to human life by shooting the deceased with a firearm, a deadly weapon, thereby causing the death of both of John, then you will find the defendant guilty of murder as alleged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of the included offense of manslaughter.
All right, so just a couple items to note. So we went through a lot of definitions, some of which are not relevant to this case, but again, as I pointed out from the earlier question, these are model instructions. So they talk about a fetus and all kinds of stuff. There's like nothing about a fetus anywhere in this case. That's one of the reasons you know it's a model instruction. You know, it says this is the definition of a person. It's just a generalized definition they have that exists. And one of the reasons that judges don't change it, even when it's kind of like not particularly relevant, is the instruction is tried and true and tested. You know, it has been through the court systems many, many times. It has been upheld many, many times. So we know that this definition is okay. If we start messing with definitions, an appeal court might overturn the jury verdict because of an improper definition. So we just might as well use the standard instruction. So we just laid out the definitions of all these terms, and we just said, if you find that she basically intended to do this and did it, or if you find basically what sounded like in my head, reckless endangerment, and killed him, then murder, and if not, a lesser included. So a lesser included offense means that this lesser offense has every element the greater offense has, but the greater offense has an additional element. So if you're missing one element, then we go down and we can see whether or not there's this additional charge. So let's listen to the definition of murder, of manslaughter, and how that plays in.
Our law provides that a person commits the offense of manslaughter if she recklessly causes the death of an individual. A person acts recklessly or is reckless with respect to the result of her conduct when she is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary prudent I'm sorry, that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint.
Now, what was really interesting here is if I heard the judge correctly, this goes to show that the definition of murder is not the same everywhere. Because like what's murder one place is not murder another place. Because when she gave the definition of murder, she was talking about intent. She was talking about purpose. And now she's talking about recklessness. And now that's interesting because in New York law, for example, recklessness can qualify as murder. So in New York, reckless conduct can qualify as murder. But according to the way she's reading the Texas law, in Texas, it doesn't qualify as murder. It qualifies as manslaughter. So it's just an interesting way to show that the definitions change from place to place, even on something like murder. So if it were reckless conduct, in this case we're being heard in New York, that might be murder, but we're in Texas, so it's not. So I thought that was an interesting note to pause.
Now, therefore, considering all the law contained in the court's charge, if you unanimously find and believe from the evidence beyond a reasonable doubt that on or about September 6, 2018, in Dallas County, Texas, the defendant, Amber Guyger, did recklessly cause the death of both of John, an individual hereinafter called deceased, by shooting the deceased with a firearm, a deadly weapon, then you will find the defendant guilty of manslaughter as included in the indictment. If you should find from the evidence beyond a reasonable doubt that the defendant is either guilty of murder or manslaughter, but you have a reasonable doubt as to which offense she is guilty of, then you should resolve that doubt in the defendant's favor and find the defendant guilty of the included offense of manslaughter. If you have a reasonable doubt as to whether the defendant is guilty of any offense defined in this charge, you will acquit the defendant and say by your verdict, not guilty. It is a defense to prosecution that the conduct in question is justified under our law. You are to consider the statutory defense of self-defense in determining if the defendant is guilty of the offenses alleged or included in the indictment.
So basically, we just let out a couple things that were really interesting there. So we heard that there's two things the jury can consider. We can consider murder and we can consider manslaughter. We gave a definition of each, and then the judge said if you're convinced that they're guilty of both, but you're not sure which, then you should return a verdict of manslaughter, which makes perfect sense because it's a lesser charge. So if you think that they did both, but you're not really sure amongst yourselves, then return manslaughter. So she's basically saying if you all agree it's manslaughter and you're not so sure about the murder count, then return manslaughter. That's what she just said, basically, in so many words. So now they're going into justification. So they're arguing, the defense is arguing that she had a legal justification to perform what she did. So they're going to explain justification and what the defense has to show or what has to be shown to make this a valid legal shooting. So let's hear about that. And yes, they do get the instructions in writing. She made that clear at the beginning that they get the instructions to take back with them, which is super helpful because I'd want to consult them many, many times as I was deliberating. So yeah.
Under our law, a person is justified in using force against another in self-defense when and to the degree she reasonably believes the force is immediately necessary to protect herself against the other's use or attempted use of unlawful force. The use of force against another is not justified in response to verbal provocation alone. A person is justified in using deadly force against another if she will be justified in using force against the other as set out above, and when she reasonably believes that such deadly force is immediately necessary to protect herself against the other person's use or attempted use of unlawful deadly force, or to prevent the other's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery.
So the ways that she's phrasing this is a little bit unique, but essentially this is the standard for self-defense everywhere. She's using slightly different words, but the ability to use lethal self-defense applies to an imminent or ongoing or about to occur risk of death or grievous bodily harm. And you might want to know, well, what is grievous bodily harm? And she just told you. She told you that it can be kidnapping. She told you it could be sexual assault. She gave the examples of what those would be. So either it's death or one of those other things which are considered in the same category of risk. So you have to show that the person you shot was doing one of those things. So that's what she's talking about. Good.
The term reasonable belief, as used herein, means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. The term deadly force, as used.
So when they say it has to be a reasonable belief, she just said it has to be based on the reasonable person. It's an objective test. The question is not did she believe it. The question in Texas is, would a reasonable person believe it? Would a person from you, basically, would you, the jury, if you're there, would you believe it? And that's the question they say. So forget what she subjectively believes. Ask yourself, would you, a reasonable person, because that's basically what the jury is, would you believe it? And that's what they're trying to say. So it's not reasonable unless you were there and you would believe it.
Used herein means force that is intended or known by the person using it to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. Habitation means a structure that is adapted for the overnight accommodation of persons and includes A, each separately secured or occupied portion of the structure, and B, each structure pertinent to or connected with the structure. The defendant's belief that deadly force was immediately necessary is presumed to be reasonable if the defendant, 1, knew or had reason to believe that the person against whom deadly force was used unlawfully and with force entered the actor's occupied habitation, or knew or had reason to believe that the person against whom deadly force was used was attempting to remove unlawfully and with force the actor from the actor's habitation, or knew or had reason to believe that the person against whom deadly force was used was committing or attempting to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated murder. And the person did not, the defendant did not provoke the person against whom the deadly force was used, and the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the deadly force was used.
So a couple of things of note there that I think are very relevant. First, she says that it can't be provoked, and that's a generally true statement. You can't use self-defense if you are the one who provoked the incident. And one might suggest that she provoked the incident. She was the one who entered this guy's home. It was his home. She provoked him. So even if he was posing a deadly threat, you could reasonably conclude that she provoked the deadly threat. So if she did, you can't claim self-defense. So even if he was posing an imminent threat, basically you started it, and play stupid games, win stupid prizes is the conclusion there. So that was a really interesting aspect.
This presumption applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption as listed above do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, you must find that the presumption exists. Even though you may find that the presumption does not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged. A person who has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force to defend herself. If you find from the evidence that the defendant was such a person, or if you have a reasonable doubt thereof, you may not consider whether the defendant failed to retreat in determining whether the defendant reasonably believed that the use of deadly force was necessary.
In other words, as you would expect, Texas is a stand your ground state. There's no duty to retreat. So if she had the ability to use self-defense, she doesn't have to try to leave first.
When a person is attacked with unlawful deadly force, or if she reasonably believes she is under attack or attempted attack with unlawful deadly force by one or more persons, and there is created in the mind of such person a reasonable expectation or fear of death or serious bodily injury to herself at the hands of such attacker or attackers, then the law excuses or justifies such person in resorting to deadly force by any means at her command to the degree that she reasonably believes immediately necessary, viewed from her standpoint at the time, to protect herself from such attack or attempted attack. In making your determination, you should consider all the facts and circumstances and evidence before you, all relevant facts and circumstances surrounding the use of force or deadly force, the previous relationship existing between the defendant and the injured party, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the alleged offense. In considering such circumstances, you should place yourselves in the defendant's position at the time and view them from her standpoint alone. Now, if you find from the evidence beyond a reasonable doubt that on or about the 6th day of September 2018 in Dallas County, Texas, the defendant, Amber Guyger, did intentionally or knowingly cause the death of Botham John, hereinafter called deceased, by shooting the deceased with a firearm, or did intend to cause serious bodily injury to Botham John, and did commit an act clearly dangerous to human life by shooting the deceased with a firearm, a deadly weapon, thereby causing the death of Botham John, or did recklessly cause the death of Botham John by shooting Botham John with a firearm, but you further find from the evidence, or you have a reasonable doubt thereof, that at the time of the alleged offense, the defendant reasonably believed that she was under attack or attempted attack with unlawful deadly force from Botham John, and that the defendant reasonably believed, as viewed from her standpoint, that such deadly force as she used was immediately necessary to protect herself against such attack or attempted attack, or to prevent the imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery by Botham John. And so believing, she shot Botham John with a firearm, a deadly weapon. Then you shall acquit the defendant and say by your verdict, not guilty.
Okay, so that was a very formalized and somewhat long-winded way to say, if you find that she committed the crime, but if she's justified, you have to return a verdict of not guilty. The justification undoes the finding of the crime. So even if you felt that she did the crime, if she's legally justified, then she wins. That's what that said.
A person's conduct that would otherwise constitute the crime of murder or manslaughter is not a criminal offense if the person, through mistake, formed a reasonable belief about a matter of fact, and the mistaken belief negated the kind of culpability required for the commission of the offense. The defendant is not required to prove that she made a mistake of fact. Rather, the state must prove beyond a reasonable doubt that the defendant did not make a mistake of fact constituting a defense. Reasonable belief means a belief that...
Okay, so now we're getting into the mistake of fact defense. So first we had the justification defense. I was legally justified. I don't think that's going to fly. So next we have the mistake of fact. I made a mistake as to what the facts were, and that mistake allowed me to make it. So this is a more interesting aspect legally, I think. So let's pay attention to this in terms of mistake of fact and how that plays in.
An ordinary and prudent person would have held in the same circumstances as the defendant. If you have found that the state has proved the offense beyond a reasonable doubt, you must next decide whether the state has proved the defendant did not make a mistake of fact constituting a defense. To decide the issue of mistake of fact, you must determine whether the state has proved beyond a reasonable doubt one of the following. 1. The defendant did not believe that she was entering her own apartment, or did not believe that the deceased was an intruder in her apartment, or 2. The defendant's belief that she was entering her own apartment, or her belief that the deceased was an intruder in her apartment, was not reasonable. You must all agree that the state has proved beyond a reasonable doubt either 1 or 2 listed above. You need not agree on which of these elements the state has proved.
All right, so a couple interesting things here in terms of what she's saying. So first of all, burden of proof is really interesting. Who has to prove this? The state has to prove this. So in some states, this would be considered an affirmative defense, where the defense would have to prove it. But in Texas, that's not true. In Texas, they have to prove it. So she said, I made a mistake of fact. The state has to prove that she didn't. So it is a mistake of fact unless the prosecution can prove it's not a mistake of fact. And they're talking about a reasonable, ordinary, prudent observer, the reasonable man test. Would you, the jury, in this position, would you have made a reasonable mistake of fact? Let's continue.
If you find that the state has failed to prove beyond a reasonable doubt either element 1 or element 2 listed above, you must find the defendant not guilty.
All right, so that's pretty interesting. If they can't prove it, then she wins. And that might be the end of the ball game in terms of this. If that's the way the law reads, then in Texas, and of course this would change, again, as I pointed out, in some places this would be more of an affirmative defense where the defense has to prove this. But in Texas, the prosecution has to prove this. The prosecution has to prove that a reasonable, ordinary, prudent observer would not make a mistake of fact. A reasonable, ordinary, prudent observer would not believe that it was her apartment, would not believe that this was an intruder. Can the state prove that? I don't know that they can. I mean, given all that we know, it seems like it was a genuine mistake. She went to the same numbered apartment except one floor above or below, I forget which, but she went to the wrong floor. She thought it was her apartment. She went in and she thought it was an intruder. So it does seem like a mistake of fact. And she said, well, if it's a mistake of fact, not guilty. So my mind on the law now as a juror, I was thinking manslaughter. Now I'm thinking not guilty because it's a presumed state mistake of fact. It's presumed. The state has to prove it's not. Based on what we know, I don't think they can get there. So not guilty is now my feeling based on the legal instruction I just provided. And that goes to show how important these instructions are because that's what the jury has to do. They have to listen to these instructions just as we all do.
If you unanimously agree that the state has proved beyond a reasonable doubt each of the elements of murder or manslaughter, and you unanimously agree that the state has proved beyond a reasonable doubt either element 1, that the defendant did not believe that she was entering her own apartment or did not believe that the deceased was an intruder in her apartment, or element 2, that the defendant's belief that she was entering her own apartment or that her belief that the deceased was an intruder in her apartment was not reasonable, then you shall find the defendant guilty as alleged or included in the indictment. You are instructed that when reading the instructions contained in this charge, you are to consider the charge as a whole. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the issue of guilt of the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with an offense gives rise to no inference of guilt at her trial.
So Charles Dyson says, did you follow the case? The apartment smelled like weed. Yes, I'm aware of that fact. And I'm also aware of the fact that the apartment was differently decorated, that she passed a planter in the hallway that should have been there, that there was this bright red floor mat she should have seen, and I'm aware of the table. So, but let's look into the question we're trying to resolve according to the instructions we've been given. So the first issue is we start with the fact that it is a mistake of fact unless it's proved not. So we start with the presumption that the defense is right. That's now our presumption. We have to go in with that. So we're filtering against that fact. So now we're asking the question, would a reasonable observer in this position believe it was a genuine mistake of fact? So now let's consider this, how this might be, how I, as a reasonable observer, might make this mistake. I'm going through my normal daily motions every single day. And as are most things that you do every day, they tend to be a little bit routine. And so you don't necessarily remember or pay attention to those things that are usual and expected. So, she wasn't probably paying that much attention when she parked. She probably wasn't paying that much attention when she went into the building. She probably wasn't paying that much attention. Maybe she was playing with her phone. She didn't see the planter. Again, we're assuming the defense is right. So when I say maybe she was doing X, I'm giving her the benefit of the doubt because I'm legally required to. So maybe she's playing with her phone, didn't see the planter. Maybe when she got to the door, she wasn't playing with her phone anymore because she has her keys in her hand and she's about to unlock the door. And maybe she hears something from inside. She hears the rattling inside. So no longer, because she went into a fight or flight response, her hearing constricts and her sight constricts. These are classic physiological responses from fight or flight responses. And I'm sure there was medical testimony to that effect. So like her senses become more attuned and constricted to the potential threat. So she opens the door. She's now in a fight or flight response. All she sees, quite literally, if her vision is constricting, and again, I'm assuming there's medical evidence to this effect, all she sees is the guy. She doesn't see that. She doesn't see that it's differently decorated. All she sees is the potential threat. And I'm sure her training as a cop probably taught her to do that as well. So, and she probably didn't notice the apartment smelled like weed. We know that he smoked weed. We don't know how much, or at least I don't know how much. So we don't know how much it smelled like weed, but she didn't notice that detail. And the question is, could a reasonable person ignore all those aspects? Could a reasonable person make a genuine mistake, given everything we know, and reach this conclusion that, oh, it's my apartment, because she couldn't smell it, she couldn't see it, she couldn't hear it, because the fight or flight physiological response constrained her ability. And again, I'm going at this from the perspective, as I was just told by the judge, I'm going at this from the perspective that it is a mistake of fact unless they can prove beyond a reasonable doubt. That's the standard I have to reach. Not more likely than not clear and convincing, beyond a reasonable doubt. That's the standard I have to reach. I have to reach basically a 95% confidence level, give or take, depending on who you ask. 95%, 98% confidence, because that's the kind of standard we're looking at. I have to conclude with 98% confidence that it was not a mistake of fact. That's the standard I have to reach to. Now, if you want to say it's more likely than not, I won't blame you. If you want to say clear and convincing, I won't blame you. But do you really want to say that you can reach a conclusion, 98% certainty, that it was not a genuine mistake of fact? Is that what we're arguing? Because I don't know that I can get there, guys, based on the record that we have. I mean, yes, there's a lot of things that should have cued her. There's a lot of things that should give her a clue. But based on the instruction we're given, based on the defaults, based on the beyond a reasonable doubt standard I have to reach, now I've changed my mind. I don't think I can get there, because they changed the law. So that's what I'm thinking. And yes, she is a cop. She was a cop at the time. So that's basically why, why I'm sort of reaching this conclusion now. I'm thinking, could a reasonable person have ignored all those cues? It's possible. It's perhaps not unlikely. It's not mere speculation, but, again, I'm just going on the default assumptions. I came into this with the conclusion it's manslaughter. That was where I started this thing. And you can look at my last stream where I, at the end of the stream, said exactly that. So you can go look back at what I said before. I came into this saying manslaughter. That was where I was working. Until she gave me that instruction about the default presumptions on mistake of fact, I was thinking manslaughter. And then she gave me that instruction. I'm like, oh, wait a second. Now this is the law I have to apply. That's the law. This is what I have to do. Can I get to 98% certainty? I don't think I can. So that's why I'm reaching the conclusion that I am. So let's carry on.
The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. This burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are instructed that if there is any testimony before you in this case regarding the defendant having committed offenses or acts other than the offense alleged against her in the indictment in this case, you cannot consider such testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offenses or acts, if any were committed. And even then, you may only consider the same in determining the defendant's motive, opportunity, intent, plan, identity, knowledge, or absence of mistake, accident, or state of mind, if any, and not for any other purpose. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit the defendant and say by your verdict, not guilty. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. You are instructed that any statements of counsel made during the course of the trial or during argument not supported by the evidence, or statements of law made by counsel not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. Mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling is to play no part in your deliberations. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given of testimony. But you are bound to receive the law from the court, which is given to you in this charge. After argument of counsel, you will retire to consider your verdict in this case. You should begin by selecting one of your members as presiding juror.
So I'll just take a brief note to note a couple things that were said in the chat here that I think are very valuable and goes to show why we have 12-person juries. Cody Sam says, personally, for so many mistakes and miscues to line up, that leads me personally to believe beyond a reasonable doubt. I think the chances of mistake are unreasonably low. Fair. And in other words, yeah. So I think, and Tactical says, I'll understand why, but it takes more than a long shift to make a reasonable person not realize she's in the wrong department. Fair. So this is like the whole point of jury deliberations, right? The whole point of why we have 12-people juries. The whole point of why we have a process. We all listen to the evidence. We're all listening to the same standards, and we're going into this thing with different things. And then we're going to talk it out. Exactly what we're doing in chat, right? So I've kind of looked through this. I've read this, and I'm like, okay, this is how I'm thinking about it. And then we go into deliberation. And I think you guys are making some very reasonable points. So, were this the real world, I'm not saying that by the time I'm done, no one can convince me. I'm just saying this is, as I was trying to say, this is what I'm going in with. This is what I'm thinking based on the instruction I'm just given, and I was trying to lay out why. But you guys would probably point out, it's like, really, Kurt? Really? She made all these mistakes? She went to the wrong door. She didn't notice the bright red floor, the bright red mat. Did you not see the bright red mat? She didn't notice that. She didn't smell the pot. She couldn't see any of the things, any of the like ottomans, and she couldn't notice anything different about the apartment. She blew by all those details. Really? That's reasonable for her to do that? Really? And so I'd be thinking, well, maybe I'm wrong, right? And that's why we argue these things out. So, and that's also why we're listening together. So we do our job as jurors. So let's carry on and finish this up.
It is the duty of the presiding juror to preside at your deliberations, to vote equally as any other juror in arriving at a verdict, and to sign the verdict on behalf of the jury. After you retire to consider your verdict, no one has any authority to communicate with you except the officer who has you in charge. During your deliberations in this case, you must neither consider, discuss, nor relate any matters not in evidence before you. You should neither consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. After you have retired, you may communicate with this court in writing through the bailiff who has you in charge. Your written communication must be signed by the presiding juror. No one has any authority to communicate with you except the bailiff who has you in his or her charge. Do not attempt to talk to the bailiff, the attorneys, or the court regarding any question you may have concerning the trial of this case. After you have reached a unanimous verdict, or if you desire to communicate with the court, please use the jury call button on the wall and one of the bailiffs will respond. Signed, Judge Tammy Kemp, 204th Judicial District Court, Dallas County, Texas. And the last 2 pages consist of the verdict forms, and you will select only one of them. The first reads, "We, the jury, unanimously find the defendant, Amber Guyger, guilty of murder as charged in the indictment." And then there's a signature line for the presiding juror to sign his or her name, and then there's a line for that person to print their name. Or, "We, the jury, unanimously find the defendant, Amber Guyger, guilty of manslaughter as included in the indictment." The same 2 lines for the presiding juror to put their name. And lastly, "We, the jury, unanimously find the defendant, Amber Guyger, not guilty." And the same 2 signatory lines.
Okay, so that is the end of the jury instructions, and now we're going to get into the closing arguments. So this is 51 minutes between them both, and we'll interrupt for commentary, so you can plan ahead accordingly. I would also take one other thing that I'm sort of thinking about as I'm sort of trying to process this in terms of what would qualify as a genuine mistake or not. And I don't know how relevant it is to this example, but I was thinking a lot about the cases where parents unintentionally leave very young children in very hot cars and those children die. And we all think it couldn't possibly happen to us, but it obviously does happen to some people. So, the idea that to me that this could all be her being on autopilot, the idea to me that it isn't even her after the long day, because I don't think that matters. It was a normal day. And to me, that's like a critical detail. It was a normal day. Everything was normal. Everything was the same. Everything was routine. And she was just going about it in a very sort of clock-like mechanical fashion. And so the idea that, I understand she's a trained cop, but the idea that, she's a human being, right, too. The idea that routine things are routine to her and she wouldn't notice that she's going about things in a mechanical way and she would not notice details because to her they're routine and being filtered out. I mean, that's the example that comes to mind is the parent leaving the kid in the car. And we all think it can't happen to us, and then sometimes it happens. And so I'm like, that's sort of what's popping into my mind. And the door was unlocked, by the way, was one of the things too. So the fact that the key didn't work so she put the key in the lock, I'm sure it would fit because it's an apartment building, right? So all the keys are the same. So the key will fit in the lock, it just won't turn. So she puts the key in the door, she opens the door, and she's confronted by the situation. And can it be a mistake? Can it have all been one massive autopilot that she made, or is that unreasonable? So these are the things I'm sort of considering in my mind. So let's listen to, and yes, to the questions you guys are asking. In a civil case, there could be a civil case for a wrongful death. So this is just the criminal issue. And in civil cases, we would reach the 51%. But of course, in a civil case, we have the qualified immunity thing. So that's a whole nother factor. But let's just listen to the defense arguments and both sides' arguments. Defense is going to go first, and then the prosecution. So let's see what they have to say.
19 minutes.
Hey, please the court. Members of the jury, defense, Amber, why are we here? The state will have you believe this is an out of control, unreasonable police officer that went on a murderous rage for no reason. That's what they're trying to show you. Why are we here? We're here because an awful tragedy occurred. An innocent young man lost his life in a mistake was made that caused that. But what you are to consider is what the law is. And what they have to disprove beyond all reasonable doubt is whether the decisions that she made in entering that apartment and believing that it was her apartment and believing he was an intruder were so unreasonable. You must determine whether the state has proved beyond a reasonable doubt one of the following: the defendant's belief that she was entering her own apartment, or her belief that the deceased was an intruder in her apartment was not reasonable. If you find that the state has failed to prove beyond a reasonable doubt either element 1 or element 2 listed above, you must find the defendant not guilty. That is the law. They don't like it. They are distancing themselves from the law. I think Mr. Fine called it garbage or trash or something like that.
I'll just take note very carefully that this is an exemplar of the maximum. When you don't have the facts, argue the law, and when you don't have the law, argue the facts. He does not have the facts, so he's arguing the law. So, yep, no surprise. Carrying on.
We're not here because whether they like the law or not. We're here because you are bound by the law. You are individuals that have sworn an oath that you are going to base your verdict solely on the law and the evidence. And the state has failed to prove anything. The state has failed to do their duty. We actually, even though we have no duty, we showed you how this was a reasonable mistake. The state, what did they bring you? Sexting and speculation. Everything that they have done has been to try to distract you and trick you from looking at the law in this case, because they know that if you apply it correctly, that Amber Guyger is not guilty. Sexting and speculation. But what it's about is Amber Guyger and how we got here. And is she an unreasonable person? Was it unreasonable for her to dream of being a police officer? Was it unreasonable for her to work full-time and go to college so she could put herself in that position? Was it unreasonable for her to join the Dallas Police Department and go through the academy and receive the training that teaches you how to use deadly force, to receive the training that teaches you that suspects' hands kill, that burglaries are inherently dangerous, and when you encounter a burglar, you go to your weapon? They had the opportunity to bring anybody from the academy to say that she acted counter to her training. Again, it's their burden. They have to prove that. They did not prove that. They brought you some standing operator procedures that we know do not apply. Because this was not a dispatch burglary call. This was not a barricaded person. This was not a situation where you have time to plan. Amber Guyger spent her life trying to do the right thing. She joined she was moved to Southeast Patrol. She joined the CRT team. She interviewed and joined a team that has to be ready at any moment to respond to the needs of the different investigative units to help them detain and arrest the murderers and rapists and the robbers. Was that unreasonable on her part? Was it unreasonable for her to work hard? You have her work records that show in August there were several times she went to work at 5 in the morning. There's some days she worked 14 hours. Some days she's got lucky and only had to work 8 hours. And those are hours where your alert level goes up and down, as we saw on September 6th when she woke up at 5:30. When she got to work at around 7:45, and immediately started looking at intelligence reports because she wants to know what crime is afoot in her area, where the hot spots are. And she has to focus and pay attention, because if you don't understand where the violent criminals are, it could cost you your life.
So I kind of like what he's doing here. You know, the facts do not favor him. He has to make the legal argument, but at the same time, you don't want to just like purely rely on law because, for very obvious reasons, the jury is human beings, and there's a person who's dead, okay, and that has to be like met with something. So you know, it's not ideal to go to the jury with just pure law and be like, just follow the pure law. I mean, because they don't want to do that, right? So you have to look for some facts to build you up. And now the facts are horrible. So like, what can you look for to try to give some facts that are somewhat redeeming in any spect? And so we show her to be generally a person of good character, generally a person who does the right thing, generally a person who's attendant to her duty. So we're trying to make her more like, we're trying to prove her to be a good person, basically. And so the argument is essentially this is a good person who did a horrible thing for as a mistake, and the law requires you to do it. It's kind of the argument. He's doing much better on closing than on opening. I'll say that for sure.
And so September 6th is a day full of ups and downs as far as alertness. They patrol regularly, looking at the different hotspots in the morning. Then they go to Central, and they have to have a debriefing with the SWAT team. And if you don't pay attention to that, because they're going after some armed and dangerous felons, if you don't pay attention, if you're not clearly have a clear understanding what everybody's role is, then a mistake can be made, and you could lose your life. So there's all these different levels of alertness. They go to the scene, they're on the perimeter, they are watching SWAT's back. They are protecting SWAT, so SWAT can get these dangerous, violent felons. Then they transport a dangerous, violent felon to headquarters. And then they have some downtime, but they're still responsible for these dangerous, violent felons, so they don't go all the way to zero. You know, when you're at a 7 or 8, when you're out on the perimeter, maybe you're down around a 4 or 5, but you're still aware, you're still working.
He's deviating into irrelevancies now. Now it's too much. You're going beyond the point. You game where you needed to be, and now you're making all these irrelevant arguments. You're off point, my friend. You're losing the jury's attention.
They make it sound like the police headquarters is a day at the spa. No, they're abiding by their duties and their responsibilities. And then they have to take the same dangerous, violent suspect to jail and get them booked in properly in jail without any incidents. And then she goes back to the Southeast substation and docks her body camera, and she goes to zero. Keenan Blair told you, when you clock out, it's a different mindset. All that day of going up and down on alertness and everything else, she goes to zero. It's over.
That's not really a good argument. If she goes back to zero, then like you just threw out huge issues of your argument. Like, is the volatility of her day relevant or not, counselor? Like, pick one or the other. If she goes back to zero, the volatility of her day is irrelevant. So everything that happened during her day is irrelevant if she went back to zero. Like, pick a side. Either it did go back to zero or it didn't. You can't argue both at the same time. You can't argue two facts at the same time. Because the jury, if you argue two facts at the exact same time, the jury's not going to believe either one of them. You're killing your argument. You have to pick a position. Unbelievable. This is sloppy.
And she gets on the phone with Martin Rivera, and there is zero evidence. They brought you zero evidence that was anything other than a phone call. Martin Rivera got up here and told you what it was. He admitted to all the sexting. He admitted to the prior improper sexual relationship. So why would he have to lie about the contents of that phone call? They want to speculate. They want to anger you at these people that are having this improper relationship. But there is zero evidence that phone conversation was anything different than the other.
That's really horrible. You don't argue you are being emotionally manipulated, because it just makes people double down. It's like saying to someone, calm down. It has the direct opposite effect. You can't do that. You can try to push them to your argument, but you can't just go at it logically. Emotion and logic don't necessarily really work that well. And so saying you're being emotionally deceived is a logical argument, and that doesn't work. You have to make an emotional argument. If you think they're being emotionally deceived, make an emotional appeal. Convince them emotionally. Don't convince them logically. Lord.
Phone conversations that they've had. And she gets to her apartment and she got lucky. And she went up in the parking garage and she backed into that parking spot. And she saw the entrance. And she grabbed her 30 plus pounds of gear and she walked straight in. And she didn't notice the skyline. Is that unreasonable? Is that criminal? Is that evil? Is that evidence of a murderous rage? And she walked down the hallway. So she had parked on the wrong floor, like nearly half the residents on the third and fourth floor have done. And she continued down the hallway towards the wrong apartment, like nearly half the residents on the third and fourth floor have done. And she got to the door and she put her key in, like 1 out of 4 residents on the third and fourth floor have done. And everything started to happen in one motion. She heard the shuffling, she's putting the key in, and we know the door was ajar. You heard from Special Agents Estes and Wallace about other people that they had interviewed where the door did the same thing. You from Texas Ranger Armstrong and saw the photos of the strike plate. You heard about the experiment that they did where the door did not shut all the way. You saw the video that shows the door is not shut all the way. Was that an unreasonable, evil circumstance created by Amber Guyger? The fact that there's no clear visual indicators on the parking garage walls, the fact that there's no numbers at eye level as you walk down these hallways of this apartment, the fact that there's no different color coding for each floor, is that Amber Guyger's unreasonable, evil action? And she gets to that door, and she obviously doesn't notice the red floor mat. Because what purpose? Why would she look at the red floor mat and say, you know what? I don't like this red floor mat. I'm going to go in and kill whoever's in here. Obviously, she didn't notice the red floor mat.
That's a pretty good argument. I can't deny that. The fact that she went in pretty much means she didn't notice it. So that's a pretty solid argument. How could she not notice it? But the fact that she went in must mean she didn't somehow. So, hey, that's a pretty solid argument. Not going to lie.
And she put her key in and it's all in one motion and it pushes open. And my God, she's hearing these things and she knows it's her apartment. She knows it's her apartment. And she goes from 0 up to 10 in a millisecond. Her heart rate starts to rapidly
The phrase, counselor, is 0 to 100 real quick.
increase. Her heart rate starts to elevate. She starts to get that tunnel vision, and she's going to focus on what she perceives is an intruder, because everything else doesn't matter. She knows she's in her apartment. The lights are off. All we have is the glow of the TV and the computer monitor. She doesn't have the benefit, like Mr. Hermes, of going through the photos with Robin Carr and pointing out every little distinct difference when all the lights in the apartment are on and she's using flash photography in those photos. Hey, look, he has a photo and she doesn't. She has a photo and he doesn't. Is that evidence she was unreasonable? That is ridiculous and absurd that they went through that. We went through hundreds of photos pointing out these differences that she obviously didn't see. She's focusing on an intruder in her apartment, and then the training kicks in and she draws her weapon because she's taught that burglars are dangerous. And it's too late now. She's face to face. Keenan Blair told you. It's different. It's not a burglary call if you walk into your own home and are confronted with an intruder. It's different. You address the threat. Michael Lee told you it's different. You address the threat. Keenan, what do you focus on? Hands. Why? Hands kill. And it's dark in there and she can't make out the hands. And poor Mr. John, he's got his AirPods in. He's smoked marijuana because we know it's in his system, and that's not relevant for any other reason than it might have added to the possible confusion and his ability to process this. He's not to blame for that. No one is. But he's trying to process this. And you look at those photos. They make it sound like he was sitting on the couch eating ice cream. The spoon is pointed away from the couch. When you're starting to eat a bowl of ice cream,
He's making the same mistake he made in opening. He's making it less than he did in opening, where it's really horrible. But he's talking about all these irrelevancies. I don't care about which way the spoon was pointed, and I don't care about the bowl of ice cream at this point. I don't care about so many of these details. You know, you have to go in with this speech that's going to, you know, be like the rousing chorus. You want to go in with something that's going to want them to come in with excitement, and you're just drowning it out in irrelevancies. You know, not as much as you did in opening, where it's really bad. Like for 15 minutes, you talked about stuff I didn't care about. But like, why are you talking to me about this? I don't care.
the spoon is within where you're going to eat it. It shows, the physical evidence shows, he probably set down the ice cream, and Amber Guyger comes into his apartment, and he's trying to process it. And all these circumstances have happened, and none of them are because she's unreasonable. None of them are because she's evil. It's because it's this storm that has come together, the perfect storm, and we know when she's standing in that apartment, she's done all these things all her life that she is reasonable. She's an ordinary and prudent person who made a mistake. She's an ordinary and prudent person who believed that this man who she's drawn a gun on, who keeps coming at her, who's saying, hey, 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 as she's saying hands, let me see your hands, as Josh Brown corroborates, she believes this intruder is coming to kill her because he got caught and he's way back in the apartment and he's coming for her. And she fires her weapon. She fires it twice in quick, rapid succession like she's taught. And to that point, she's done everything like she's been trained to do and taught to do, and then she realizes what had happened. Now, the physical evidence is important because they have concocted a narrative that has zero support in the physical evidence. And that is so crucial. Because when you look at the evidence, when you look at Michael Lee's body cam, and you go to 5 minutes and 26 seconds in, you see the feet position of Mr. Jean. You see right there, no one's moved the body. They tried to make it sound like the body was being moved. The body was lifted up. The feet were lifted up, but this is before the feet were lifted up. You see Mr. Jean's feet. They're lined up with the frame of the bedroom. You see his right foot right next to a flip-flop and his left foot a little further out. So his body is facing the doorway.
Counselor, why on God's earth are you showing a picture of the victim during your closing? You're reminding the jury the victim exists. This is not helpful to your case, okay? The victim did nothing wrong. Why are you showing a picture of the victim? Why are you showing a picture of the victim with blood on the floor? Do you secretly hate your client? Is that what's going on?
And so it's reasonable from the evidence, and what Amber Guyger told you is that he's coming forward, and he's facing the doorway because the shot is straight on. The shot doesn't deviate either way. He's coming towards that doorway. Hey, who's in my apartment? And he sees the gun. The last thing she saw is this figure that's upright coming at her, and he gets shot. And that's consistent with the angle. And that's consistent with him falling right here because he had a rapidly fatal wound. It is pure conjecture. It is pure speculation to try and say that he would have taken 2 purposeful steps. That is out of the imagination of the state of Texas.
Yeah, 3.
Why do I care if he took steps after he was shot? Why do I care?
Thank you, Judge.
I missed what the judge said. Hold on, I have to go back a second.
Imagination of the state of Texas.
Yeah, 3 minutes remaining.
Thank you, Judge.
So she said you have 3 minutes remaining. So apparently these things are timed in Texas, which incidentally is not the worst idea. But yeah, carry on.
You have the AirPods that you can see are just lying right next to Mr. John's ear. I find it hard to believe and hard to fathom if he was somehow getting up off the couch that he would have perfectly navigated the ottoman, walked towards the person that just shot him. So for some reason, he's been shot. He's walking perfectly in a straight line towards the person that just shot him. The AirPods are still in his ears and somehow stops and falls back. That is preposterous. That is the conjecture that the judge has told you not to engage in. The investigation by the Texas Rangers. So the Texas Rangers come in. The Texas Rangers, one of the most elite investigative units in the country. And Ranger Armstrong told you what he did, because he wanted to know. His focal point was her coming to that apartment reasonable? And every step he took of the investigation and everything he did showed that it was. The canvas, was that significant, Ranger Armstrong? Oh yes, it was significant. The door, well yes, it does. It corroborates Amber once again. The parking garages, the layout of the apartment complex. The physical evidence corroborates what Amber Guyger told you. The state...
Okay, guys, I'm not a criminal defense attorney, and I've not ever done a murder case, but I'm fairly convinced I could give a better closing argument than this guy. It's just blowing it. He's blowing it from a narrative point. He doesn't know how to tell a story. He's killing my soul a little bit. You know, there are some things here that are not bad in terms of like composing a story. Same thing in opening, where he had like some things that you could make a story out of, but he's burying it in all these irrelevancies. I don't care about all this stuff. Why are you telling me a story about things I don't care about? He's blowing his argument. This is making me sad. Maybe Amber should have hired me. I could do better than this.
Texas cannot bring you one shred of evidence, anything that shows that she was unreasonable. The state of Texas cannot bring you one shred of evidence to support their absurd hypothesis about him sitting on the couch. Ladies and gentlemen, thank you. Thank you for your time. Thank you for letting us take you away from your families. This case is a case that depends upon you to look at the law and look in the evidence. And it's clear, if you find the state has failed to prove that she was unreasonable, if you find the state has failed to prove that she was unreasonable in her belief that Mr. John was in her apartment and that he was an intruder, you must find Amber Guyger not guilty. Every single one of you has the power to say not guilty. If the state did not prove this case beyond a reasonable doubt, if a single reasonable doubt remains, each and every one of you has the right and the responsibility and the duty and the courage to say not guilty. Ladies and gentlemen of the jury, the evidence is clear. We've proved it. They certainly have failed to disprove it. That Amber Guyger firmly believed reasonably that she was in her own apartment, that Amber Guyger firmly believed in those seconds that she was facing an intruder. The law is clear. Your duty is clear. Find Amber Guyger not guilty. Thank you.
Okay, guys. So I say this as a person who earlier this stream explained to you in some detail why I was leaning towards a not guilty verdict. He just completely screwed that, and I've ceased to care about his client, and my inclination now is basically convict. So basically, he just screwed himself out of a potential acquittal, because it's like you told me you have some elements here that are workable. He actually started strong. He started well. He had a good point at the beginning, and he had some stuff throughout. But man, he drowned it. He drowned it in irrelevancies. Okay, when you're talking about story, you have to separate plot from background, right? The story is the elements that of reality that we care about. Background is things we don't care about. And you only tell background to the extent it helps to service the story. He told us the background. He made everything the story. He doesn't know how to construct a story. Horrible closing. He started off strong, and then there was a whole lot of I don't care, and he finished unbelievably weak. The last 3 minutes when he was called time was just so weak. I was like, unbelievable. So what do we want to give this guy? Let's say 2.5 out of 10. It's pretty bad. Let's see if the state can do any better.
Mr. Hermes, I've given you an additional minute, so you have 27 minutes.
May it please the court. I think really, and I'm going to get into the legal issues in this particular case, the factual issues in this particular case, but I think where Mr. Rogers just left off and where I'm about to begin really does underscore the difference of opinion. Because the state of Texas does absolutely find it unreasonable that a trained 5-year veteran of the Dallas Police Department could go into the wrong apartment and shoot an unarmed man who is doing absolutely nothing wrong in the chest.
Okay, so 10 out of 10 open. That was pretty freaking good. I remember this from my trial practice days in law school, where we did mock trials and prepared this. We spent what would be considered a unreasonable amount of time basically writing the first sentence and or first paragraph of our openings and closings. Of the amount of time we spent writing it, we spent a grossly disproportionate amount of time writing the first sentence, because you want to get their attention right out of the way. And he just said, we consider it completely unreasonable. This trained officer of 5 years did all these things. And once again, as a guy who was explaining to you a little bit earlier why I found it reasonable, I'm listening to that. I'm like, yep, it's completely unreasonable. You're 100% right. So like, wow, way to change my mind, counselor, because you just 10 out of 10 opening line. The other guy should take notes.
The state of Texas finds it absolutely unreasonable that a person could do something like that and just say, whoops, my bad, and then go on about her life however she chooses to do. Yes, the state of Texas finds that premise to be unreasonable. In fact, we find that premise to be unjust and unacceptable and insulting. A 5-year trained police.
Just want to take note, he said unjust, unacceptable, and insulting. Roll of threes, always good practice. So just a short note there. He said 3 things. So he has read a manual on how to give a argument.
Officer who, as a matter of her ability to perform her job effectively, is trained to observe and to orient and to maintain situational awareness. We're not talking about somebody who just walks around, every day doing whatever else. she was given a special job at the Dallas Police Department, a position, because her observation skills, her awareness skills were that good. That is not where you put the slackers or the sleepers. So yes.
That slacker and sleepers thing is a nice Johnny Cocker move with the alliteration. Excellent.
To accept the premise that she could just walk into somebody's home who was no threat to anybody, kill that person, and then walk away with, geez, I really messed up there, is absolutely unreasonable. And it's unacceptable on a human level. Now let me just talk to you about where we are legally in this case. The facts that are undisputed right now are that on September the 6th, 2018, here in our community of Dallas County, Texas, this defendant shot with her firearm Botho John, killing him. And by her own admission on the 911 call and in this courtroom, it was her intent at the moment she shot to kill him. Those are the elements of murder, proven beyond a reasonable doubt. And those elements and those facts are not in dispute. So that's a starting spot.
Okay, so if that's true, my previous assumption of manslaughter has become a lot more shaky, and now suddenly I'm starting to consider, well, maybe murder would be the appropriate verdict. If she really said, my intent was to kill him, I'm suddenly thinking, maybe this is murder after all. So you've opened my mind to a possibility that I wasn't considering before, so you're pretty much kicking butt.
This defendant has committed murder. All right? To that charge, she and her team asks for you to give her the justification of self-defense. She has claimed that she was acting in self-defense at the time that she shot Mr. Jean. And Mr. Fine did a fine job going over all of the requirements that a person has to have in order to have the benefit of self-defense. Because I'm here to tell you, as a state's attorney, there are times when you have to use self-defense righteously and reasonably to save your life. And that's fine. That's why it's there. This is not one of those cases. And I'm just going to, and Mr. Fine put all of the elements up there for you. I'm just going to talk to you about two, because she would have to have all of them in order to benefit from that justification. I'm going to show you where she fails on the two most important. First, and understand the premise of where these are coming from, because you have to kind of understand the background to appreciate why these words need to be given the meaning that they deserve. The premise is the sanctity of life is paramount. Life matters. If there's a reasonable alternative to taking somebody's life, then you are not going to benefit from the defense of self-defense, ever. And rightfully so. That is an option that the legislature has given us as a last resort when there are no other options. And why would it be any less? Why would we want to kill another human being when we could have done anything else? Right? So let's just talk about a couple of things that are required. Number one, in order for this defendant to benefit from self-defense, her decision to use deadly force must have been immediately necessary. And those are the words, ladies and gentlemen, that I need you to hear and give those words effect. When the legislature said immediately necessary, when we in our community have adopted this, those words mean something. Immediately means now, this second, at this moment. God bless you. That's what immediately means. It doesn't mean it.
Nice little pause there with the God bless you for the sneeze. I know it's probably instinctual, but still, I'll give credit for it anyway. It was a nice one. And yeah, they say immediate, but imminent. Yeah, same concept.
In a few seconds or a few minutes, or if this should happen or if that should happen. It means right here, right now, I have to act. Nothing less. Necessary. Necessary means that you have to do it. There's no other choice. If you have a couple of different options that you could reasonably do, then killing somebody is not necessary. And unless you have the confluence of those two doctrines where it is immediate and necessary, you do not get to kill somebody and say, whoops, too bad, I'm going on with my life. So let's just talk about this concept first. What are the actual facts of this particular case when it comes to her decision to use deadly force and whether that was immediately necessary? We've long suspected her decision to use deadly force was made in the hallway. We've long suspected that because the keys were left inside the lock, which were indicative of her pulling her gun. She needed that right hand, and obviously if she had a free right hand and she really believed this was her apartment, she would have taken out her keys as she was going in. Well, the trial confirmed that. Because not only on her direct examination, but on cross-examination, I made it very clear to go over this with her 2 or 3 times. She was in a position of safety behind a steel door in the hallway when she says that she made the connection between the fact that her door wasn't locked, it was ajar, and that she heard somebody on the inside. She was out.
Okay, that's pretty solid. That's pretty solid. She was outside when she made all those connections. If you got that in testimony from her, and you went through it 2 or 3 times, and she was outside and she made all those connections, your mistake of fact argument is beginning to disappear. I thought justification was pretty much a loser from the start. I thought mistake of fact might work, but if she's confessing basically that when she's out in the hall, she's making a decision to engage in force at that point, your mistake of fact argument is beginning to disappear rapidly. So, like, yeah, he's doing a kick-ass job.
Outside the door. She knew there was someone inside what she thought was an intruder. In fact, it was actually Mr. Jean doing absolutely nothing wrong. But she had the advantage of knowing someone was inside, and she assumed it was an intruder, and she decided from outside, from that position of safety, that she was going to engage what she calls the threat, and she decides how she's going to do it is by pulling her gun, opening that door, and going in to engage him.
Holy shit, dude. Holy shit, you know, she didn't pull the gun when she was inside and he was doing something. She pulled the gun before she opens the door. Holy shit, dude. So my opinion has changed pretty solidly. I'm back to doing where I wasn't even at the start. I'm now in my own mind debating between murder and manslaughter. I didn't think murder was going to work, and now I'm thinking murder's sounding a lot better. I'm now debating between those two. That's where I am.
And what does that mean? That means she had options. That means deadly force wasn't immediately necessary. By her own admission, she didn't have to even retreat. She could have just stayed in the position that she was if she wanted to. Mr. Shook brings up this thing about the radio, about how we're trying to talk about after the fact. No. I'm talking about right then and there. She had a police radio on her. She had her cell phone on her. From that position where she was safe, outside that door, she could have called for police and said, I have an intruder. Apartment 1478, or whatever apartment she wanted to give. She could have called for anybody to have come. They could have treated that like a barricaded person. They could have contained it. They could have used loudspeakers. Probably Mr. Jean would be alive had she decided to take the less lethal option. But she didn't. Because in her mind, at that moment in time, she decided to go in and engage that intruder. Now let me illustrate one other point that I think is critically important. By its very nature, self-defense means you're acting defensively, right? Does that make sense? What does it sound like she's doing? She isn't.
Holy shit, dude. That's a pretty good line. Holy shit, dude. That's a 10 out of 10 line right there. Wow.
A position where she is safe and secure, where she has options that she could have called for help. But what does she decide to do instead? Staying out there, calling for backup, calling for help, maybe even taking a different position of additional safety was an option that she had that she decided not to do. She didn't decide to do any of those defensive things. She became the aggressor. That's not self-defense. She decides from outside that door, I'm going in, I'm advancing, I'm engaging, and I'm going to deal with that person inside. And she's already indicated how she's decided to deal with them. She has a whole belt full of tools. She chooses to go after the gun, which is the most deadly weapon that there exists out there. And she tells you that she's going to engage. And what she does as soon as that door is open, and Mr. Shook, I'm just going to beg you different. My recollection of the testimony was that she put the key in the door and it opened up slightly. And I stood there at that gate the other day and I indicated every single time, pushed it open a little bit, pushed it open a little bit. And I said, was it then that you heard this person inside? Yes. Then she indicated with the left arm, she opened up the door fully and that she used the left arm to keep that door open. That she used her gear to help keep that door open. She must have done that because she had her gun in her right hand. She had already committed to a course of action. While she was in the hallway, the only thing that was going to be the difference of life or death for Mr. Jean was how long it took her to find him as soon as she got into that apartment. The second that that door was pushed open by her and that gun was out, she was scanning that room until she saw Mr. Jean. The light from the hallway, the hallways have these bright lights, floods into the room, and she's scanning the room. And Mr. Jean, unfortunately for him, he made it easy. You know, not only is he getting up from a seated position, but he's also saying, hey, hey, and these are normal reactions. He's pointed himself out immediately to her. And as soon as she acquires him, she shoots. How do we know that? You heard the testimony of Joshua Brown. Joshua Brown talks about this exchange where he hears, hey, hey, hey. He says as soon as he heard, hey, 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 right after that, 2 gunshots. There was no long conversation like Mr. Shook indicated. As soon as Mr. Jean identified himself and she was able to acquire that target, she shot him. And if they'd given you the suggestion that somehow it was too dark for Amber Guyger to see, ladies and gentlemen, she shot him dead in the heart.
Well, that's a pretty solid point, isn't it? It's too dark to see, but I managed to shoot him directly in the heart. Well, that's pretty solid, yeah. And the witness who heard it didn't hear she say like any sort of surrender moves. She went immediately to shooting. So yeah, you've pretty much sold me on murder. I'm sold. So let's go with murder. Yeah. Okay. Well, that's been a roller coaster of a thought process for me, but that's where we are.
That's not a mistake shot. That's an aimed, well-executed shot. The second bullet goes slightly above where his head would have been had he been fully standing up and out the wall. She's tracking him up from the couch as he's getting up, and the second shot goes up a little bit high. She saw exactly what she was shooting at. She also had, outside in the hallway, additional options. She didn't just have to stay where she was. She could have taken a position behind that second set of fire doors. She could have repositioned herself down the other side of the hallway. She had a host of options that a reasonable person would have done. Not just a reasonable person, but also a trained police officer. One thing that Mr. Shook, although he wants to, and Mr. Rogers, they talked a lot about what Officer Blair said, but they forgot to mention Officer Blair also telling you and me that if he was outside his apartment or outside his home and he knew there was an intruder inside, he wouldn't go in. He would respect the sanctity of life. He would call for backup. He would have taken a position of cover and concealment. That's another police officer, another person who is trained like her, who would have been using common sense and reason and appreciating the value of life. For Amber Guyger, Mr. Jean was dead before that door ever opened.
I like the comment someone said that we're running out of floor space for microphones, because like we're running out of floor space for microphones. I mean, holy God, dude, this is master's class stuff, man. Oh man.
And that's just the simple truth. I want to talk to you about also a little bit about her departure from training. Mr. Rogers wants to say that you really can't factor in what her training requirements are because this wasn't a dispatched call. Repeatedly, Amber Guyger testified that she would resort to her training in her everyday life. She was off duty when she backed her truck in, but police officers do that because they want to be able to get out quickly. She resorts to her training in her common everyday life. She talks about how she keeps her right hand free in case she needs to draw for her weapon. She was off duty when she did that. Why then would she abandon training and orders that she has had that is gauged for her safety? When confronted with a person inside of a building, Dallas police officers, and you've got it, I encourage you to read it. Standard Operating Procedure 1509, I think, 15 or 1709. It says 4 different times, one time in all capital letters, do not go in. Call for backup, take a position of cover and concealment. This is for your safety and their safety. Only go in when the scene has been contained and backup has arrived. You know, you can't have it both ways. You can't say, I'm going to take advantage of my police training sometimes and not others. Keenan Blair would have taken advantage of his training and he wouldn't have gone in. Also, I want to talk to you a little bit about this idea about loud commands, because I think that's also indicative of where Amber Guyger's mindset was about that both of them was going to die. She didn't give loud commands. There were 5 to 10 witnesses that live within earshot of this particular apartment. All of these individuals indicate that from the hallway you can hear when people are speaking and moving. Not one single person ever heard her say, show me your hands. Not once, let alone twice. And they talk about the power of the state to bring anybody down that we want. They have the exact same power. There were 300 people at that apartment complex who were interviewed that had some, all, or no information to share. If there was any single person that heard, let me see your hands, they would have been in here. Not one person heard that because she didn't say it. Because again, the truth was she made the decision to kill from outside that door. And once she put into play, she executed that plan perfectly by entering that door and shooting Mr. Jean. Let me talk.
I am not this good, guys. This guy is better than me. I'm not better than this guy. He's better than me. I'm just like, it's just, I want to take classes from this guy too. I mean, he could teach me some stuff. He knows what he's doing.
Talk to you about the other aspect of self-defense that I think clearly evidence shows that she woefully failed. And that is that in order for you to be allowed to use self-defense or deadly force to kill somebody else, it has to be in response. It has to be for you protecting yourself against another person's use of deadly force against you. All right? It's not just a matter of that it's immediately necessary, but also it has to be to protect you from deadly force being projected on you. And I still, as I stand here right now, I wonder what the defense is suggesting both of them Jean did that constituted deadly force on Amber Guyger, that would have allowed her to use the justification of self-defense. There is no question, it is undisputed, he was unarmed. That man had no pockets. There was no place he could have even hidden something. That wasn't his way anyway. There's absolutely no dispute that she saw a weapon or saw something that she thought was a weapon. I mean, how many times have we heard from police, oh, he pulled his cell phone out and I thought it was a gun or something. There was none of that. All Mr. Jean did was get up from a seated position to see what the person was coming in. The only other reasonable alternative was him cowering down behind that wall that separates him from Amber Guyger. Getting up from a seated position or cowering down to avoid getting shot, there is no way that any reasonable person can interpret that kind of body position as being deadly force. There's just not. And if the defense wants to somehow suggest that him being bent over at an exceptionally deep angle, like this it would have to be, what was he going to do? He had an ironing board in front of him. In front of that, there was a 3-foot kitchen counter in between him and Amber Guyger. What was he going to be doing, leaping over like some sort of a ninja? There is absolutely nothing that Botham Jean did or that she could have even reasonably perceived that projected deadly force on her, against her, having failed both of the most important parts of self-defense. She doesn't get it. She doesn't get it. And I understand, I'm not actually agree with Mr. Rogers about something, about the effect of sympathy. Because see, one of my concerns is that facts like that really matter, the fact that both of them couldn't have been any kind of a threat to her at all, I'm scared that you guys might just decide that that doesn't matter to you. Because see, you got to be in a courtroom and look at her for 7 days. She got to get up here and talk to you. You know? Because of what she did, this is all I can bring in.
Holy shit, dude.
Mr. Jean can't come into this courtroom and appeal to your sympathy or to your emotion. He's been reduced to a cardboard photograph. So I implore you, please, please use your common sense in how you interpret this law. Self-defense is an option of last resort. She killed him unreasonably and unjustifiably. And just because she wants to throw out that I did it in self-defense, I need y'all to critically apply the facts that you heard in this case before you give her that. Because again, the state of Texas proudly takes a position. This is not one of those things where you could just say, whoops, too bad for you, buddy, you're buried 6 feet under, I'm going on about my life. No. If they thought that I was ashamed of that position, I've never been more proud of a position I've ever taken. Killing this man was unnecessary and it was unreasonable. It was unreasonable from start to finish. She had options outside that door when she had no danger. Options that didn't involve any violence to anybody. She didn't want to use it because she wanted to engage him. And everything after that was just a mere formality. We have proven the offense of murder. We have proven that the justification of self-defense doesn't apply on at least 2 grounds, any one of which requires it to fail for her. Amber Guyger is guilty of murder, and the state is entitled to that verdict, because that is the just verdict, and it is unacceptable that there could be no consequence for all of her unreasonable acts and her unreasonable decisions that she made at that time. Now, the defense points out that in the charge, you have been given the reasonable mistake of fact. And Mr. Fine was very careful and he was very clear on how that applies as well. It is a reasonable belief standard. And thank you, Your Honor. And that reasonable belief standard is based upon not only what an ordinary and prudent person would do, but from her circumstances as a trained police officer. And it was unreasonable. Listen to just this partial list of everything to do with where she was. Okay, she missed the roof line. She missed the floor number placards that are on the elevator. She missed 16 or 17 apartment numbers going to her door. She missed decorative flower pots and different kinds of floor mats on the floor. Most importantly, and this is the one that just can't be overcome, there was no other floor mat like this in the entire building. This thing sticks out literally like a red thumb. You can't miss this. When I carry this around the room, in this gray room, kind of like the gray floor at that apartment complex, you can't miss this. And she walked up to it and stood on top of it. Now, Maybe Guyger didn't allow that to process in, but that's not the standard. It's whether an ordinary prudent person with that kind of training and observation skills, no reasonable person would have missed this. That's not all though. She missed the smells. The different smells about the room and the hallway. She missed all the furniture. Look inside those apartments. Look inside. They're not furnished anything alike. And from her vantage point, she could see entirely in. She missed the artwork on the wall. She sticks her key in, and as it's going open, she saw that red light blinking. And she knows that means that the lock doesn't recognize the key. She recognized the door wasn't locked when she knew that she locked her own door. All of these things would have put a reasonable person like Miss Rose, who testified, would have put a reasonable person on notice to take a second. Take just 1 second and think about what is going on and what everything is telling you that this is not right. And she just refused to do that. She didn't even consider the fact that maintenance would be inside. I mean, she was on notice that maintenance was coming by that particular week. Now, I understand it was late, but anybody who's lived in an apartment knows that that's a possibility. It may be a remote possibility, but you may have somebody from maintenance in your room with a burst pipe, a small fire. You just can't walk into an apartment and start shooting, especially when you know that there might be somebody like from the apartment complex that's inside there. And let's talk about the reasonableness again. As Jason said, what kind of burglar goes in, sits on a couch, and is watching television? Now, let me just move on to that because, and also don't forget, there's actually no signs of forced entry. And that goes to the Castle Doctrine. In this particular charge, yes, she's asking for the benefit of the law that protected both Johns. And that's just wrong, but it's there, and y'all get to consider it. But in that, there has to be forced entry of an occupied residence. That doesn't exist. There has to be evidence that he was trying to push her out. That doesn't exist. Or there has to be evidence that he was trying to kill her, rape her, or somehow assault her or rob her. None of that exists. None of that exists. And they question, how is it that we're so confident that Amber Guyger walked in and both John was sitting on the couch? It's because it is the only explanation that fully comports with the 3 sets of physical evidence that existed on the scene. Number 1, the trajectory for the bullet that hit the wall. Number 2, the scene context of what's going on right in that immediate area, as far as the ice cream and such. And number 3, the wound path that the medical examiner testified to. This is number 1. This is the trajectory of the bullet that hit the wall. Look where it goes. It goes right in front of that center cushion of the couch. It goes right over the seats of this couch. This is the trajectory that both bullets were following because you know that they were rapid shots. There wasn't time for a quick movement. Number 2, the scene context. The physical evidence from the scene context. They want to put a lot of emphasis on the spoon. Well, take a look at the top of the spoon. It's dirty. It's been used. Now, I don't know why Mr. John would have put the spoon up that way. Perhaps there was a big piece of ice cream that was in the way. But you can tell this is where he's sitting, and this is the reason why. Number 1, you heard how much he wanted to enjoy this bowl of ice cream. I can tell you as a big guy, when I put ice cream in a bowl, it's not going to sit there unattended. That's just a fact. Number 2, you've got on the couch, you've got the center cushion that's open, you've got pillows on the right, you've got a blanket on the left. Next to the ice cream, you've got your remote control, you've got your laptop computer, and you've got your cell phone. Everything that he could possibly want is right there. That ottoman, when Officer Blair and Lee walk into the apartment, it's pulled up right to that center area as well. This was his nest. This was what he was doing. And when you asked the 3rd piece of physical evidence, when Dr. Gwynn was on the stand and he was testifying about the trajectory, he said, absolutely. The bullet path that I found in the body is consistent with a person getting up from a seated position. And it absolutely is. For Botham Jean, who was sitting, and the TV would have been right where you ladies are right now, he would have been watching that. The disturbance would have come to his left and towards his front. As he is getting up to find out what that is, he is shot as he is saying, hey, hey. They're talking about how it's remarkable that he is able to walk a couple of paces. The doctor testified absolutely he would have had the ability to do some purposeful movement. There was no damage done to the spine that would have dropped Mr. Jean like that. He was able, because it was his intent to look and see who's coming through that apartment. He was able to take a couple of steps forward before his body failed him. That is the only explanation that fits with all of the physical evidence. The only other reasonable possibility, and I admitted this during opening statements and I embrace it now, was Mr. Jean hiding, getting down as low as he could to get behind that small 3-foot counter because he saw her coming in with a gun. Either way, Botham Jean was never a threat to Amber Guyger. Never. Justice needs to happen in this courtroom today. For over a year, there has been injustice in the city. And Mr. Jean and his family have waited for a year for justice. You 12 people get to write the last chapter in this story. Although there's been injustice and indignity so far, you can restore justice to this case. You can say, Botham Jean, you did nothing wrong and you did not deserve to die. By your verdict, you can also tell her, you will be held responsible for what you did. And whether or not you want to accept responsibility, it's going to be forced upon you. And by God, in Dallas County, Texas, there will be a consequence for you walking in and shooting an unarmed, defenseless man. Thank you.
Well, I thought the judge said you're out of time, and this is really my only point of critique. When you're out of time, you get to finish your sentence, and that's about it. So he talks for like a good 30 seconds over. Not that it will matter in the end, because holy shit, dude. I don't know if you noticed, but I was beginning to tear up a little when he was talking about the cardboard picture and stuff like that. I was like, holy God. He had a really great mix of logic and emotion. He kept going back and forth, which is really good because you don't want to burn people out on emotion. And so it's like you just go back and forth between logic, emotion. It's like, oh my God. And it's just like, can you please stop winning? I'm tired of winning. Man, oh my Lord. Wow.
The jury may retire to deliberate the verdict.
All rise.
All right, well, that's the end of that, guys. So yeah. So the jury got the case this afternoon, and they left at 5. And so I don't know exactly what time this afternoon they got it, but they were deliberating for like 3-4 hours, something like that. And they resume tomorrow. So we will see what happens next. No verdict yet. So yeah. I would recommend a plea deal if one is being offered at this point, because yeah, that's a lot of stuff when they're talking, reasonableness is viewed from the point of view of the reasonable man, and she had all this training and stuff, so that factors into it. It's like, holy Lord. So it's like, man, yeah, pathos, ethos, and logos, right? Man, does the prosecutor get a score? I mean, it was pretty freaking solid. 9.5 out of 10 overall. There were a few things that I would have cut. But the other thing that I would have noted too is the line with the cardboard stuff was by far and away his strongest point. And I would have ended with that. That's where I would have ended to give that last emotional kick. So I thought it was a mistake that he put it where he did in sort of the dialogue, because it was so good that I'd want to end with it. Now, maybe the reason he didn't is because he was concerned about running out of time, and so he didn't want to leave it for the end in case he did. But that was my biggest point of critique. It was like, I thought that was a really solid thing. I mean, it got me tearing up in my eye. And I'm like, why not end on the emotional point? Because the minute you stop speaking, as we just saw, the minute you stop speaking, they're going to go into the jury room. So why not give them that last kick in the gut as they go into the jury room, and so they're factoring that into how they're going to start their deliberations. So Lord have mercy in heaven. Yeah, I mean, can you get a plea deal at this late in the game? Yeah, sure you can. I mean, you can get a plea deal right up until the time the jury verdict is read. So you could technically reach a plea deal after the jury reaches its verdict, as long as it's before it's read. So I don't know if the state's offering one, but man, oh man, that was 9.5 out of 10. Pretty good. Yeah, the last moment you can accept a plea is the moment when when the verdict is being read by whoever's reading it. Usually it's the judge or the clerk, but so that's what's going on. So yeah, I started the stream thinking manslaughter, and then he said this legal standard. I'm like, oh well, geez, that's pretty good. They have to prove it beyond a reasonable doubt. Now I'm thinking not guilty, and because of his argument, I went from not guilty to manslaughter to I'm debating between the two to now I think it's murder, because like he just the really the strongest point for him was emphasizing the intent, because that's where it really comes down to, right? Is the intent element. For me, that was by far the weakest, because I'm like, did she really have the intent to do this? And he just hammered that over and over and he didn't hammer it all at the same time. He hammered it, and then went away from it, and he hammered back, and he went away from it, hammered back to like point out that she had the radio, that he had the thing, that he had the time, she had this training. And I really like the fact that where he argued like, you can't have it both ways. You can't have it both where she's trained and that she's not trained. It's like, that's really solid. It's like, wow. Yeah, it's like so my only reason I didn't really give a 10 out of 10 was because I thought that the best point for him was in the wrong place. I would have ended that with that, to remind the jury of the human factor, because it was such a good point. I'm like, oh my God. That was my only critique. So 9.5 out of 10, outstanding. It is master's class, and I'll probably watch it again to learn something, because wow. Yeah, it was really, really good. David, there is really no stream schedule during the week because I'm busy at work, and so I can't guarantee it. So I don't really have a stream. I just kind of do it when I need to. We're playing around with streaming regularly on Twitch around 1 p.m. For having the weekly stream. So that's kind of that. But during the week, I don't have a regular stream time. I'm posting a story a day around 3:30, 4 o'clock, as I'm sure you've noticed. So my releases are pretty consistent. And I've got a full week worth of stuff pre-queued, which is nice. But yeah, so I'll do my typical thing. If you like the stream, please hit like, and please hit the bell, and please hit subscribe. So if you hit the bell, you will get notifications of when I'm streaming, and then you will not be disappointed and stuff. So yeah, hit the bell, and that way you should hypothetically get notifications from YouTube, assuming that is actually working. As a prosecutor, even with this, I would think about offering a plea. Because it's like, you never know what a jury is going to do. Like, the absolute most I would ever, as a lawyer, think is 95% I'm going to win. Because, you never know. And now it's pretty solid, and the facts are really good. And it does demand justice. But I'm like, if I could get a plea to, I'd be thinking about a plea to either murder with a reduced time, or maybe maxing out manslaughter in the first degree. Because I get the verdict on the record, I get the confession from her as part of the allocution, and I ensure a verdict that can't be reversed, because I don't have to worry about things because of the plea deal. And that's another reason, it's because of appeal. Not that I've seen any appealable issues, but again, it's like, you want the guarantee. So my name on Twitch. What is my name on Twitch? Is it Blackleaf31? It is Blackleaf31. So you can go subscribe to me on Twitch as well. I'll just confirm it. Yes. So it is Blackleaf31. Here is my channel that you can go subscribe to that. And you can watch me play. My most recent video was a game. You can watch me play the ad game, I Love You, Colonel Sanders. I Love You, Colonel Sanders, a finger-licking good dating simulator. Also, I cover legal content on there. So it is twitch.tv/Blackleaf31. So you can go subscribe to me there, and I'm streaming on there. And also, for those of you who are watching, I will again take note that I'm taking suggestions on the channel name. Thanks to Tactical Bra, our mod, I have changed the name temporarily to Uncivil Law. I haven't committed to that, but we're playing around with it, as we're playing around with so many things, as we're learning by doing. So if you have an opinion on the issue of Internet Law Review versus Uncivil Law versus whatever, I will now take your suggestions in chat. So you can let me know what you think, and I will give you a minute to type rather than just immediately saying, I'm going to close the stream, because I have to give you a minute to type. I know Tactical Brow likes it. It was your idea, and it was a very good idea. I like it. The idea from her, as she explained to me, is because we cover stories that are a little bit more off the beat, a little bit more unfriendly. So we cover the stories other legal commentators won't cover. Wink, wink. So the idea was on civil law, because we're willing to stretch the bounds of what and also that because law sometimes relates to uncivility, so it's pretty good. So yeah, thank you for the follow. Thank you for the likes. I will thank you for the super chats as well. Can I get a list of all the super chats so I can thank him? I know Joe Tyson gave me $20, so thank you, Joe. Is there a way for me to see all the super chats in one place? Probably. Let's see. As I said, I'm learning by doing, guys. I don't know. Did anyone else see who live control room at the bottom? I'm in live control. I don't see anything at the bottom. I see. No, I don't want to super chat myself. Create highlight video, insert ad. I don't want to insert ad. Share, stream settings. Nah. Does anyone know who else super chatted so I can contribute to them? Because I can't figure it out because I'm an idiot. I want to thank the people who super chatted. Oh, well. Well, thanks to all the people who super chatted. I do appreciate the support. Please remember to also check out Lawful Masses with Leonard French, my good friend Leonard French, your favorite copyright lawyer and mine. You can find him Lawful Masses with Leonard French is a YouTube name, and it's twitch.tv/Lawful Masses, right? So we'll remember that, and old country room, not the new one. Well, we are where we are. We're stuck with this, so next time we'll figure it out. Make sure to give him a follow and like if you've not done so already. He produces great content, and I love hearing what he has to say on so many issues. I love the video. It was dropped today on the catfishing from the Match.com. I thought it was a really, really good topic, and I was really happy he covered it because, man, there's a lot of deception out there, as I know all too well personally, trying to find a new girlfriend. So I have too been deceived by Match.com at all. So, I look forward to my eventual settlement of $20 from the eventual class action. So very exciting for all. I'm going to sign off for now. Thank you so much for joining me on the stream. Hit like, subscribe, bell, all the rest of it. We tune in around 3:30, 4 o'clock Eastern time for the daily release, and when I do live streams based on my time and availability. Hope you all had fun. Love you all. Good night.